First of all, good afternoon to all of you. Welcome to yet another meeting of the Belgrade Legal Theory Group. And before I introduce to you our distinguished lecturer for today, let me first wish happy Labor Day and Orthodox Easter for all of you who are celebrating. I have an honor and I'm privileged to moderate today the lecture of my dear friend and colleague Boško Tripković. Boško teaches and research at the Birmingham University Law School in the UK in the field of jurisprudence, constitutional theory, constitutional law, and EU law. He has published extensively, both in Serbian and in English language, but worth mentioning today is his book entitled The Meta-Ethics of Constitutional Adjudication, published by Oxford University Press in 2017, in which he has developed an original theory of the role of values in constitutional reasoning. Let me add that Boško won a Cappelletti Prize for the best thesis in the field of comparative law defended at the European University Institute in 2016. And he also got the Special Mention Award from the International Constitutional Law Review for his article, The Morality of Foreign Law. Today, Boško is going to speak on the topic entitled Existence and Justification of Human Rights. Those of you who work in the field of human rights know that the issues related to human rights related to nature and the recognition of human rights are still debatable. Human rights scholars have never had anything like complete control over the definition of human rights. Broadly speaking, there are those who think of rights in moral terms and those who think of rights in political terms. But everything about that you will hear from today. You will hear today from Boško. So, Boško, the floor is yours.
Thank you so much. I hope you can hear me. I'm delighted to join you for this talk. It is great to see so many familiar faces and some new faces, and to be back after so many years, even in this virtual form. And it is also a pleasure to see all the fantastic work that Belgrade Legal Theory Group is doing, and to see it really becoming a global hub for cutting-edge discussions in legal theory. So, as Violetta mentioned, and as you have seen from the title of my presentation today, I will focus in my talk on the existence and justification of human rights, and more precisely, I will explore the ways in which human rights may be thought to exist and how this bears on their justification. The main claim that I want to put forward is that there are good reasons to think that human rights ultimately exist in virtue of social practices, and that they are justified by a plurality of values, some of which do not pertain to valuable features of human beings. And if we would want to situate this argument within the wider debate about orthodox and political conceptions, this would be perhaps a third way, which is much more sympathetic to the political conception, but which thinks that political conceptions do not have a good explanation of how practices ground human rights. Roughly speaking, although I won't mention many more about that debate today, this is how I would situate it. Now, to support this main claim, I will make three basic argumentative moves. First, I'll present two competing views about the grounds of human rights, which lead to different conclusions about their existence and their justification. The first view, which is dominant, and which I will call foundationalism, and it is the view supported by orthodox theorists of human rights, hold that the existence of human rights is not ultimately contingent on social practices, and that their justification exhaustively depends on valuable features of human beings. Now, the second view, which I will call anti-foundationalism, and which I will ultimately support, denies both of these theses. It considers human rights as being ultimately contingent on social practices, and it sees their justification as not being exclusively determined by valuable features of human beings. Second move that I will make, I will contrast and compare a foundationalist and anti-foundationalist conception of the existence of human rights. And then I will draw attention to a number of reasons, which are often neglected, why anti-foundationalism better explains such existence. And third, I will then explore the implications of anti-foundationalism, or just that anti-foundationalism opens a space for the idea that rights are justified by plurality of values, which are not of human beings. Yeah. So in sum, my argument will be that despite the near consensus in favor of foundationalism, there is a range of neglected arguments that in fact make anti-foundationalism the better view of the grounds of human rights. Okay, so let me move to the presentation itself. The first key issue is that I will talk about the grounds of human rights in contrast and compare these approaches in terms of how they explain the grounds of human rights. And it is important, therefore, to explain a little bit what I mean when I talk about the grounds of human rights. Now, the grounds of human rights are the more fundamental features of reality in virtue of which human rights exist. So, for example, we may think that the right to life exists in virtue of the value of human dignity. We may think that freedom of expression exists because of the value of human agency or autonomy. Or we may say that rights to fair trial and political participation, among other things, exist in virtue of certain institutional properties of contemporary societies, such as adjudicative processes and so on. Now, in each of the examples that I mentioned, the existence of a human right is explained with a reference to a more basic entity of defense, and without which there would be no such right. So the notion of dependence that I'm relying on pertains to fundamentality, not in a sense that humanity is not a previous event or an action which has brought about the right to life. As a more fundamental entity, generate such a right as a less fundamental entity. And so, as I said, foundationalism and anti-foundationalism are basically different conceptions of human rights grounds. The key claim of foundationalism in terms of human rights grounds is that they are grounded in our humanity and that they belong to human beings as such. Now, this claim is then cashed out in terms of moral human rights, which are then said to exist in virtue of valuable features of human beings, such as their agency, interests, or needs. The grounding relation between the valuable features of human beings and moral human rights is crucial for foundationalism because it underpins the foundationalist understanding of universality of human rights. According to foundationalism, human rights are both diachronically and synchronically universal. They have existed at all times and in all places, even in a state of nature, and independently of any actual institutional or social recognition. Now, the idea is that because human rights are grounded in valuable features of human beings, which allegedly do not vary across space and time, such rights belong to everyone, and in that sense, they are universal. It's really important because this is the main motivating factor behind foundation explaining this notion of universality, so understood. Now, this conception of universality motivates two foundationalist theses about the grounds of human rights. The first relates to the existence of rights. For foundationalism, the existence of rights is at the most fundamental level, independent from contingent. Why? Because if human rights are that, then they must be more fundamental feature of reality upon which they depend. And then the most fundamental grounds of human rights also need to be independent from contingent and evolving frameworks of evaluation embedded in social practices. This is the first thesis. The second thesis then relates to the justification of rights. Foundationalism confines the most fundamental grounds of human rights to normative considerations which pertain to valuable features of human beings. Again, because these features are seen as immutable and independent from contingent social practices, this allows foundationalism to account for diachronic and synchronic universality of rights and for the status of all human beings as right holders. Now, to contrast this view with the view that I will eventually support, it is useful to look at these two theses again. And so the way that I understand anti-foundationalism here is a combination again of two theses. The first anti-foundationalist thesis is that the existence of human rights is not ultimately practice independent. According to anti-foundationalism, the existence of human rights at the most fundamental level depends on social practices, which in turn ground normative values that again in turn justify human rights. And the second anti-foundationalist thesis is that justification of human rights need not be based on valuable features of human beings only. Now, this thesis does not follow directly from the first one about existence, but because anti-foundationalism is not wedded to this view of universality, which attaches human rights to features of human beings, its account of justification of human rights can include a wider range of normative values. What matters for anti-foundationalism is that justification of rights both reflects and strikes the appropriate balance between normative considerations integral to human rights practice. Now, as I mentioned in the beginning, I will argue that anti-foundationalism better explains the existence of human rights and then draw implications of this explanation for their justification. So let us move on then to the second part of my talk. I will talk a little bit about the existence of rights as the first and primary issue that I want to focus on. Now, to compare anti-foundationalism and foundationalism as frameworks of understanding human rights grounds, it is useful to focus on the question of diachronic existence of human rights, the question of how human rights persist through time, basically. And a grounding framework, any grounding framework of this sort, should be able to explain two intuitions about diachronic existence of human rights. First, some claims about universal diachronic existence of human rights do not appear to be true. Yeah? For instance, the proposition that the right to a fair trial or free elementary education of cave dwellers existed seems false. And this is so for a number of reasons, including the fact that cave dwellers did not think of themselves as having such rights. There was no political authority to claim such rights against. There were no institutions to which the content of such rights pertains. And even if cave dwellers had the rudimentary notion of right to fairness or minimal educational provision, it is doubtful that these would apply beyond the immediate social group in a way in which human rights normally apply today. Now, the second intuition that needs explaining is that some claims about human rights do seem to export across time. It is, for example, meaningful to say that Genghis invasions violated human rights of the civilian population. And this claim is intelligible irrespectively of the lack of human rights vocabulary at the time, and seems to hold even for rights which could be seen as less central, as we've seen the latest decision of German Constitutional Court in a similar way ascribes human rights to future generations. And so it seems that in this sense, claims about human rights export across time. Now let us look at the foundationalist explanation of these intuitions. Now, foundationalism can respond to the first category of claims about diachronic existence of human rights basically in two ways. First, it can accept that some human rights of cave dwellers did not exist, for example, but argue that the more basic moral human right or principle, which can ground such less fundamental rights, for example, the right to fair trial or free elections, existed at the time. So on this view, contemporary institutional practices would simply implicate or trigger the more basic right or principle, and thus generate the less basic right, such as right to free elections or right to a fair trial. However, the problem is that this explanation does not sit well with the foundationalist conception of human rights grounds. Why? Take, for example, the right to fair trial. Even if cave dwellers had a rudimentary conception of the right to be treated fairly, there would still be an across-the-board failure throughout much of the history to notice the central deontic implications of such rights. For example, one of the main ones being the duty to establish independent and impartial institutions that would secure the right to fair trial, such as courts. The problem with this explanation is that it reverses the grounding relation at the core of foundationalism. It is not the case that the right to fair trial is simply triggered by the existence of contemporary institutions such as courts, which provide, for example, a new context in which the right to fairness applies. Instead, the requirement to establish such institutions should follow from the right to be treated fairly, based, again, human interests in fair treatment, which presumably obtains at all times. And the same for many other rights, such as the right to free elections, corporate to create institutions that make their protection and enjoyment possible. Now, this is for foundationalism. It is only the beginning of the problem, because second response from foundationalism can be to accept the implication that human rights existed but were not recognized by humans. For example, if the existence of human rights is ultimately independent, then it is possible for all the participants in human rights practices to be mistaken about human rights. Now, the key question then is how we can reliably track this realm of practice independent human rights. The difficulty is to explain why we are able to access the domain of practice independent rights, while such access wasn't available to our ancestors. In offering such an explanation, foundationalism needs to demonstrate basically that our current epistemic access to the domain of practice independent rights is more reliable than it used to be. But it is not clear how such an account would look like. Foundationalism relies on the notion of derivation of rights from their grounds to explain this, but that process must be abstract enough to be grossly misapplied throughout history, but at the same time, it needs to be specific enough to generate an attractive list of particular human rights. Now, even if this problem can be overcome, it is very difficult to see how such an account would be verified. On one hand, if this account of epistemic access to practice independent domain of human rights practices, and such beliefs can also be in radical error in relation to the realm of practice-independent rights, and thus it can equally be unreliable. On the other hand, it is not really open to foundationalism to argue that such epistemic access is based on the grounds of human rights, which are self-evident, or that such practice-independent verification is not necessary. Why? Because the former, the idea that grounds of human rights are self-evident, would just beg the question. It is precisely the beliefs about human rights grounds that are subject to this controversy, such as the belief that human rights are grounded in valuable features of human beings and so on. So it's not open to them to treat them as axiomatic. The latter option, to say that such practice, that verification of this access to practice-independent domain is not necessary, would allow for a normatively dangerous gap between human rights practices and practice-independent human rights to exist. And this leaves open a possibility that our practices are in radical error in relation to human rights requirements, basically normative of human rights, and that we can be completely misguided about the true normative requirements of human rights. So this is the puzzle for any foundationalist account. Now, there might be other ways out of this conundrum, and we may talk about them in the Q&A section. But I think this problem is significant enough to warrant an analysis of a possible anti-foundationalist solution. Now, recall that anti-foundationalist account of human rights grounds makes them ultimately practice-dependent, which suggests that human rights of cave dwellers did not exist. Now, this explains the first intuition that I started with, but it may, however, lead to obstacles in explaining the second intuition that I previously identified, which implies that normative judgments about human rights do actually export across time. And that, moreover, should anti-foundationalism indeed be unable to explain this, this could undermine our ability to normatively assess contexts in which human rights are not actually accepted in contingent social practices. This is the danger with anti-foundationalism, and perhaps one of the main motivations why people are attracted to the foundationalist view. The first obstacle is less problematic. The first obstacle is the one where foundationalism might not be able to explain normative judgments as they export across time. Why? Because anti-foundationalism grounds the existence of human rights in social practices. Were such exporting intuitions to be meaningful, it only needs to be the case that our contemporary practices do, in fact, ascribe rights to human beings in a way which holds across times and places. And the way in which we actually speak of human rights in practice does not presuppose that they apply to others only if they accept also basic precepts of human rights, but that human rights apply notwithstanding their attitudes. For example, the prohibition of torture applies not only to the cultures which accept it, but to all cultures, irrespectively of their recognition of prohibition of torture, for instance. In other words, social practices which ground human rights determine the perspective of evaluation and not of the evaluated. And in the same way, our practices ascribe value to human beings irrespectively of the historic period in which they lived. And this is what enables us to meaningfully talk about there being human rights violations, even if human rights were not recognized at the time, even if humans were not aware of such rights at the time. Now, this is fine, but the key concern with the foundation is whether this explanation undermines the normative authority of human rights. And here I want to suggest that anti-foundationalism does not need to undercut the critical potential of human rights in problematic ways, and that in fact there may be some normative advantages to explaining human rights in anti-foundationalist terms. This is so because normative practices are complex. They're sensitive to their purposes, and they allow for coherence-based reasoning. It is possible to conclude that a part of human rights practice does not advance the purpose of the practice as a whole, or that it is inconsistent with a more general principle accepted in practice, or that it does not fit the most attractive interpretation of that particular principle, and so on. And at the same time, the recognition of contingency of human rights does not need to lead to practical inaction. The fact that human rights are practice dependent does not imply, or let alone logically entail, the illegitimacy of interference when central practice are violated. Rather, what I think it does it requires a careful reflective exercise to determine the boundaries of the core evaluative commitments of the practice, which includes the notion of respect for differences and protection of the values at the core of such common and evolving evaluative framework embedded in social practices. And I think that this more careful approach to imposing our understanding of human rights on others should not be seen as a limitation of anti-foundationalism, but actually its advantage. Moreover, anti-foundationalism as well other normative, first, most crucially, as I explained when I was talking about foundationalist understanding of diachronic existence of human rights, anti-foundationalism solves the problem of the potential disconnect between human practices and practice-independent human rights. Anti-foundationalism allows us to reclaim the knowledge of human rights, because the normative content of rights should not even potentially be completely alien to our normative practices. If the true normative requirements of human rights are possibly completely detached from our normative practices, it follows that all those involved in such practices could be completely wrong about them. And then the question is, what confidence can we have to presuppose that we are reliable in our judgments about human rights? On the other hand, if human rights are practice dependent in this way, they're constantly reconstructed, reimagined, as prone to changes that better reflect contemporary normative commitments. We see human rights as something like an ever-developing work in progress, so figuring out how to best protect important features of human beings, and then balance this concern with other relevant normative considerations. Yeah, so, for example, this opens up more substantial space for change and adjustment. We may extend the requirements of human rights to both in terms of their scope, for example, to include a more expansive conception of social rights, and in terms of their bearers, we may extend them, for example, to non-human animals, and so on. So that's the second bit of my argument, which is to sum up that anti-foundationalism better explains the existence of rights. Now, how does that relate to justification of rights? There is no direct relation, except that foundationalism itself presupposes a particular view of human rights justification because they are committed to the view that human rights are grounded in valuable features of human beings. Foundationalism is, because of this, foundationalism is opposed to the idea of what I call external justificatory pluralism, the view that normative content of human rights is grounded in multiple normative values, some of which are external to valuable features of human beings. Yeah. So, for example, foundationalists would typically claim that this external justificatory pluralism is alien to the very notion of human rights, that it's untrue by definition, or that it goes against the idea of how human rights are constitutively determined. Now, if it is the case that human rights are ultimately grounded in social practices, then the range of their justificatory grounds cannot be restricted by appeals to the nature of human rights, which is allegedly antecedent to such practice. And instead, the answer to this question will need to be sensitive to the range of justificatory grounds of human rights which are embedded in the practice. There is no reason to consider only some of such justificatory grounds as constitutive if they all play a significant role in practice in determining the normative content of rights. Now, this is not to say that the question of human rights justification will not further depend on a normative question of how much weight we want to ascribe to each of these justificatory grounds in particular context, or even whether a particular justificatory ground should continue to play a role in the grounding base of human rights. Rather, human rights practices will only settle the prior issue of whether certain kinds of normative considerations are necessarily excluded from the grounding base of human rights just in virtue of their practice independent nature. So it diffuses a certain kind of argument from foundationalism, which claims that human rights are grounded only in valuable features of human beings. Yeah? And now, if we actually look at the practice of human rights, it suggests that a range of normative considerations actually feed into the conclusion that human rights require something or that they're violated or not. Reasons, for example, democratic self-determination, sovereignty, respect for cultural differences, that are already embedded in human rights practice, which ultimately grounds the existence of human rights. And this is the connection with the political conception that Violetta talked about. For instance, it is counterintuitive to think that there are human rights violations that are justified on the basis of democratic self-determination or the principle of sovereignty. In such cases, it is more accurate always to say that there are no human rights violations in the first place. These kinds of external considerations are typically considered to be important in making normative judgments about human rights requirements. And while the importance of the protected feature of human beings is the crucial normative consideration when we make these kinds of judgments, it is always balanced against other reasons which are external to the protected feature of human beings before an abstract right is actually recognized as a human right and before a complete conclusion about the content of a human right is reached in any particular case. Now, you may ask, even if this is so, and the nature of human rights does not conceptually exclude these kinds of external forms of justification, there could still be reasons to restrict the justificatory grounds to valuable features of human beings only. And I think that an important intuition behind the foundationalist conception of human rights is that human rights are actually primarily concerned with protecting human beings and giving expression to their equal value. However, this intuition about protection of human beings need not entail that the normative content of human rights must be grounded in valuable features of human beings only. And in fact, the value of such protected features can only be grasped and appreciated against the background of these external justificatory grounds. And there are plenty of arguments out there why this is so. One of the important ones being the so-called threshold objection, which says that the threshold beyond which an interference interference with a valuable feature of human beings does not amount to a human rights violation. An example, for example, is Griffin's claim that human personhood, understood as normative agency, is the only justificatory ground of human rights. Now, this ground obviously seems too inclusive. Many inclusions on normative agencies, such as nudging and so on, do not amount to human rights violations. Then the temptation is to reduce human rights protections to the minimum conditions for the exercise of human agency. But this again seems too restrictive. The minimum conditions for agency are satisfied even in circumstances of systemic human rights violations such as slavery and so on. And so Griffin, for example, extends such minimum to include the conditions for a successful realization of human agency, such as minimal education, information, resources, and so on. The problem with this move then is that there is no principled agency-based reason to determine the content of human rights in such a limited way, in a way that Griffin would want it. Successful realization of human agency could potentially ground all the protections necessary to secure preconditions for leading a good life, which would go well beyond the exceptional and special character of human rights guarantees. And similar problems arise in relation to any foundationalist conception of justification. The problem is that this threshold of human rights protection depends on the consequences of determining the normative content of human rights in a particular manner. The key such consequence is justification of a particular form of universal concern for the interests, status, and needs of human beings. The value of the features of human beings, such as agency, needs, and so on, protected by human rights, needs to override the reasons which count against making protections of such valuable features a matter of universal concern. And so there are at least three, there may be more such external reasons. Sovereignty is the internal autonomy of states, even if they're not fully democratic and just. Democratic self-determination, which allows the states to pursue the democratic preferences of their citizens, and respect for example, the society to follow their culturally embedded social norms. Now, once these external reasons are introduced, then it becomes clear why certain important moral rights, such as the right that others keep their promises given to us, are not human rights. Even systemic of such rights is not significant enough to override the reason to solve the democracy by international concern. And conversely, paradigmatic human rights, such as the right not to be subject to torture, do override external reasons. International concern and protection of such rights is justified even against the views of sovereign states, even against the decisions of democratically elected institutions, notwithstanding different cultural practice. So the content of human rights claims is not fully fixed with a reference to particular property of human beings, but also with reference to such external reasons. Yeah. So to bring this to a close and sum up, the main argument is that anti-foundationalism explains the existence of human rights in virtue of contingent social practices, and it accounts for their justification in virtue of plural normative considerations that are embedded in such practices. And I argued that there are good reasons to accept the anti-foundationalist account of human rights grounds because it avoids the suspect metaphysical claims of foundationalism. It retains our ability to know an agency to develop human rights requirements. It explains how the threshold of human rights is determined, human rights protection, and it does not undermine at the same time normative significance and critical potential human rights in problems. So thank you so much for your attention. and I'm looking forward to your questions.
Thank you, Boško, very much. Thank you for this excellent and inspiring lecture. I'm sure that we learned a lot from you, particularly regarding this distinction that exists in the scholarship about the nature and recognition of human rights. So now it's the time for Q&A. You have in the chat the rules regarding how to ask the question. So you can follow that rule, or you can simply raise your hand like this, and I will give you a floor. Okay. Miško, did you?
I didn't, but as long as you somehow call my name, I may come up with
Sorry,
with
but
a question.
I'm still new in this
No,
internet.
no, it's okay. First of all, I'm really glad to welcome our colleague and friend Boško at this group's series on different talks in legal theory. And as we all know, this part, which is dedicated to human rights, is a particularly vivid one with a lot of presentations so far. So this was to start with very elaborate defense of anti-foundationalist approach to human rights, and as far as I am aware with the literature, probably the most elaborate one I've met so far, having in mind the early anti-foundationalist approaches to the subject matter. My question would be, by the end of your talk, you mentioned the sum of human rights, which in a way enjoy a particular privileged status. You mentioned right to torture, right not to be tortured, obviously, or and we all know that these particular rights are commonly also enlisted as non-derogable rights or absolute rights, and so on and so forth. And it seems that such status calls for some type of justification. Otherwise, all non-foundational approach can say about this is merely to describe the situation as such and say as, okay, we have something which enjoys a privileged status, but why is it so? It seems that pushes us back to some sort of foundationalist response, or at least it seems so on first glance. So I want to hear your thoughts on this problem. Thank you.
Thank you. I'll just write that down for later reference. I agree that this is a particularly useful example to analyze the two paradigms, especially because in the case of absolute rights, it seems at least that they are not subject to this kind of analysis, which would include external justificatory grounds. Now, there are several ways to explain the property of absoluteness in anti-foundationalist way. The most important one being, which is not something that you will find very new, is the idea that these kinds of this kind of reflection that I described in the second part of the talk when I talked about justification actually occurs also in the context of absolute rights. It just occurs in a different place and goes to the determining the scope of the right rather than determining the limitations of rights. Now, this is still not good enough as an explanation, and still may push me back to some form of foundationalist explanation. The second explanation is that simply for certain kinds of persons, the balancing exercise is reached. We are much more certain that prohibition of torture is wrong in all circumstances, although we are not always certain what that actually means. And so we fix their normative content in a different way from the rights where the practice hasn't really settled these dimensions. Again, this, I think, wasn't really the key to your question. The key to your question was that the primary explanation for why we want to have certain rights as absolute goes back to the question of valuable features of human beings. And so the objection, as I interpret it, is that this conception kind of gets things the other way around, the wrong way around. We instead of talking about the importance of valuable features of human beings, we are talking about all these other things. And this is the victory point then. I'm not saying that valuable features of human beings are not important. I'm actually saying that these are the most important, this is the most important element of justificatory exercise that we go through when we determine normative content of human rights. However, what I'm saying that it is not the case that we can access this importance of valuable features of human beings without actually considering a range of other reasons which bear on qualification of right in this or the other way. And so, although we have these kind of fixed notions where we are kind of certain, and have been for a long while, that human rights are determined in a particular way, that does not mean that initially the exercise does not need to go through the same process of reasoning. And moreover, it does not mean that we are still not doing that in a different way. I suppose Anna, who's doing the PhD on this topic, will have an opinion on this, but certainly the case of, for example, the ECHR, absolute right minimum level of severity, things like that, they're always subject to certain kinds of considerations. And this is where this area of uncertainty arises, and this is where these external reasons become important again. Hope that answers it somewhat.
As a helping hand to Violetta, Dan Pavlovich, I think raised his real hand, if I quote that correctly. So I'm unmuting you, Dan. You should be good to go now, but we can't hear you still. Yeah, I know. Could be something with your mic.
Maybe you could also type the question if there is a chat box that sometimes works.
Yeah, there definitely is. But this has now become the folklore of WebEx and Zoom meetings. I mean, somebody wants to ask a question, he can't ask a question. It's always like this. So everybody's accustomed
to all these platforms.
Yeah.
Until Dejan manages, maybe someone else.
We have a question from Nedim Kulenović, so I'm unmuting you, Nedim.
Hello, can you hear me?
Yes.
Yeah, well, first of all, thank you very much for this talk. Just one conceptual question. So I'm wondering concerning the initial distinction made by Professor Beširović that is more familiar, namely distinction between orthodox or moral and political conceptions of human rights. How does this debate between anti-foundationalism and foundationalism fit into this? Because, I'm sorry, I'm in an elevator, so there is noise. So as we know, one might think by just intuition that perhaps moral conceptions would be more, comfortable with foundationalism and political with anti-foundationalism. But as we know, some of the leading moral, theorists of moral conceptions, such as John Tasiulas, are very strongly anti-foundationalist. And he has put his arguments against foundationalism, almost 10 years ago, particularly in his attack on Griffin. So I'm just wondering, how does this debate between, foundationalists and anti-foundationalists fit into this other debate between, moral and political conceptions? Thank you.
Very good question. So the key way to distinguish the two is to really look at what some people think when they say anti-foundationalism. My approach is much more related to people like Richard Rorty and people writing in that tradition than in a sense in which Tasiulas uses anti-foundationalism. Basically, for Tasiulas, anti-foundationalism means that justification of moral human rights is plural, so not related to a single feature of human beings, but related to multiple features of human beings. And so, but he would exclude the idea of these external considerations. He calls them, in his other work, calls human rights as constitutively determined by justificatory grounds which pertain to valuable features of human beings only. So he would not accept this idea. And I think that the way in which he draws the distinction between foundationalism and anti-foundationalism, and obviously everyone is welcome to define their terms as they want, but it does not fit philosophically with what anti-foundationalism usually is taken to mean. So basically, although I think Tasiulas's view is better than traditional foundationalist views such as Griffin, it still does not go far enough. When it comes to political conception, for example, does not accept this metaphysical commitment that the ultimate grounds of human rights are practice dependent. So they say that human rights theory should be answerable to human rights practice somehow, but it is nowhere clear, at least in Rawls, Bites, and people like that, why that commitment, where does that commitment arise? Why should we think of human rights as being somehow, the notion of human rights somehow being answerable to human rights practices? It might be my methodological commitment to, the same way that Rawls distinguishes between kind of conceptual analysis of law and perhaps evaluation. So we may want to say, well, look, this is what human rights are descriptively, and then we may want to reject them, improve them, and so on. So they're two conceptually distinct tasks. But I'm not sure, for example, if you look at Bites, Rawls, of course, doesn't even mention this, but if you look at Bites, it's not clear where does this commitment come from. For me, this commitment is metaphysical commitment. It's commitment to the idea that if human rights are metaphysically grounded, human rights practices, this is what explains why we need to start from practices. Whereas for them, this is not necessarily the case, and for us, it's openly not the case. So there's the distinction. And then I arrive to the conclusion, which is similar to some political conceptions, but via a different route, and I think better better route in terms of the metaphysics that's behind it. Okay?
Okay, thank you. Diana, did you manage to put yourself online? No? Okay. Okay, then someone else. The floor is yours.
Can I add one more question, Violeta?
Yes, go ahead.
Boško, I just crossed my mind. You were not mentioning, but this may also be a question for the anti-foundationalist view. Does anti-foundationalist view commit one to a certain meta-ethical stance? Presuming that the foundationalist view is somehow attached to one particular meta-ethical doctrine of moral objectivism or realism, whatever you call it, does the same hold for the anti-foundationalist doctrine? Thanks.
Absolutely, yes. That is the key distinction. Thanks for that, Miško. That's the key distinction. Anti-foundationalism is, at least when it comes to the existence of right, the explanation of existence, also anti-realist, as opposed to realist explanation. And so, for example, most political conceptions are also realist, as much as orthodox conceptions are. So this is the key distinction from which I then develop my view.
I was made aware that Damir Banović, our colleague from Sarajevo, has a question. Damir, am I right?
Actually, I don't have because the problem is I got in a lecture quite late, so I don't want to ask something which has already been mentioned. So I'm still just listening. No, I have no questions actually.
I was misinformed then because I got the direct message about it. I didn't want to put you in the spotlight in any way. Sorry.
Yeah, I'm just thinking about Boško's presentations, and I mean it's for me his points were quite clear because I was also writing something in an area of LGBT rights and Foundation for LGBT rights. So his theses are quite familiar to me. So I have nothing special actually to ask. So sorry. If something comes, I'm gonna or later
Sure.
on.
Okay, while you are thinking about what to ask Boško, I have a proposition for my colleagues who are teaching legal theory. In my capacity of the editor-in-chief of Pravni zapisi Union University Law School Review, I would very much like to have the book review of Boško's book that I mentioned to you in my introductory notes, The Meta-Ethics of Constitutional Adjudication. And Boško will provide, and even you can have, Boško, correct me if I'm wrong, but even you can have, you will obtain from the Oxford the book for this task. So I'm putting this on the floor also. It does not necessarily have to be for this or the fall issue, but maybe for the spring issue next year. Think about it.
Thank you, Willa.
Violeta is not in the capacity of managing editor only while she sleeps.
That's true. So Boško, obviously you made obvious things even more obvious. So the people,
Yeah, although it's quite controversial.
yeah, although
It might be the other explanation is that people are just disagreeing so much that they don't even.
I don't think so. I think that I'm right. My view is right. Okay.
So there, if I may, from the position of the possibility of unmuting myself at will and starting the conversation anytime, I think that Violetta is mostly right. The thing with anti-foundationalism, the way Boško presented it, strikes me as quite obvious. Which is of course a virtue, and I'm not enough into philosophy of human rights in order to, but a couple of questions were raised from Miodrag and from Edim, I think, about those issues. It is something that strikes me as obvious in contrast with some essentialist theories of human rights, but my question would be on the basically what are the most, from the perspective of somebody who isn't deep into the philosophy of human rights, what would be the foundationalist, the basic foundationalist, or the basic reasons for holding a foundationalist position when it comes to human rights? And now related to, also I'm relating this to Anna's PhD, because it since Anna mentions it quite a lot when we have the chance to meet. So I usually think of or we usually think about absolute rights as giving us the reason for some sort of foundationalism. When I think about those rights, I usually think of the treatment, which is a little bit obscure, but still, there was this at the end of the 80s when Habermas was writing Communicative Action. Everybody was asking him, why do you still need the conception of a priori? And he was adamant to say because of National Socialism. So that was his answer to it. Kind of like this entire idea that having a foundationalist conception of something guards us from diving deep into, especially when it comes to human rights and when it comes to political theory now. So if I formulate a foundationalist political theory, nothing bad will happen in political systems ever again. Or I will have a certain position from which to criticize, but I'm not sure that you lose all this stuff when you switch to an anti-foundationalist position. The thing is with these positions, and I was really glad to listen to your talk because of this. It is something that in the things that I worked on was given up a long time ago, like, for example, pragmatist philosophy or hermeneutics. So it isn't, at least for me, it isn't something that I can seriously disagree on, except when we are talking about, I don't know, bodily pleasure or pain or chemical reactions or stuff like that. So that would be my comment question for you.
It is an excellent question. I think, I mean, there are two questions. One is, what is lost with anti-foundationalism? Why would people be committed still to foundationalism? And I think it's precisely the reason that you mentioned, which is that they think that this puts human rights on more solid ground and allows us to reclaim human rights in the face of diversity, in the face of different kinds of challenges that we are experiencing today, populism, authoritarianism, call it what you want. Yeah. Now, my answer to that is that if this is the only thing, if the idea that, philosophical idea that human rights are ultimately grounded in a practice, independent way, is the only thing that is going to save us from populism, then we are really in trouble. And in fact, I think that there is some sort of tension in the foundationalist view, which is based on this idea that the protection of human beings, which is a noble idea, but there is also deep distrust of human beings embedded in that view, which says, well, we want to protect human beings, but we don't really want human beings to think that the way that they should be protected is up to them. And that I find problematic. So I don't think that, I think it's the intentions behind foundationalism are noble, but I just don't think that it's persuasive, and it actually can be in a way counterproductive, because if you say, well, human rights matter only as long as they have these kinds of practice-independent foundations, once you undermine that view, then it kind of follows that human rights don't matter. Whereas what I want to say, they do matter, even if this is not the case. So in a sense, that would be the distinction. And the second question that you mentioned in relation to absolute rights, again, I think that's also right. And then there is something there that resembles some sort of foundation, and that may be a little bit problematic for anti-foundationalism to explain. However, in the whole idea of anti-foundationalism is not that there are no foundations, in the sense that there are no things which are more or less important. It's just that all of these foundations, if you want to call them, are contingent and also revisable in social practice, subject to change. And so even within our practices, we can distinguish between more and less important things. But it does not mean that the more important things are some sort of entity which exists outside of our practice. Yeah, that makes sense.
Thank you. There is a question or a sort of statement of Dan. So Boško, you can read in the chat.
That's right. So if you are to rely on practicing external foundational forces of culture. Yeah. Yes. So the question is how much, if we ground human rights in social practices, does that restrict certain kinds of progressive policies that we may want to have, or more progressive, whatever that means, understanding of human rights? And the second question that I detect from this is the idea that this whole notion that we constantly balance the importance of human beings with certain other principles, such as state sovereignty, democratic self-determination, and so on, is kind of problematic in itself, because that may lead to a certain kind of protection, which is less robust. I think actually, if you think about human rights in terms of anti-foundationalism, that allows us to break free from certain dogmas, which sometimes, if you think about things in foundationalist terms, we may fall prey to. For example, if you think that human rights or some sort of rights which apply in a universal way are based on valuable features of human beings, then it's going to be very difficult to imagine a world in which you would have protection of non-human animals in a similar way. But if you think about human rights as grounded in practices, then you may be more open to the idea that the same kind of care or universal concern that we pay to human beings ought to be paid to non-human animals. Things like that. So it allows, I think, the change to occur in an easier way. That, of course, is equally a problem, because as Bojan and Boško and others were saying, that can also lead to reversal into certain forms of protection, which we may not find as attractive. That's another question. But I think that scope for change is much wider within anti-foundationalism. The second issue of of balancing rights with external consideration, how far that kind of thinking may be dangerous. Of course, it can be dangerous if inappropriate weight is ascribed to this external consideration. For example, if you look at the development of ECHR, in the beginning, there was a lot of reference to state sovereignty and deference on the basis of that. But nowadays, it does not play such a big role. So we can see that human rights practices are progressing in a way which decreases the significance of these external features. However, I think it would be perhaps naive to think that these kinds of considerations do not play a role. They certainly do. And I think that they do have a place. It may not be a very significant place, but they do have a place even in today's world, and provide some kind of counterbalance to certain human rights claims which may not actually be justified to my taste, if you will. Yeah. So yeah, you can look at it from both angles, I think.
Thank you. Damir.
Maybe you were talking about this, but I mean, I think both theories, I mean, have foundational theories have the good sides, of course, their bad sides, but also anti-foundationalism is good in the sense that, I mean, if it's based on social practices and, but I mean, do you think that this kind of theory is parochial also? I mean, in sense, I mean, do we also have a concept of what's a social practice? Or, I mean, how do you actually conceptualize the social practice as the basis of something which could be anti-foundationalism for the conception of, I mean, I know this, I mean, anti-foundationalism is more real, more realistic in this kind of sense, but it's very problematic in the concept of what you consider a social practice, or then the human rights are really parochial. I mean, the concept is quite parochial, or it's like actually concentrated in some areas of the world. That's a
good question. Yeah, very good question. So my answer to that is that first, social practices can occur at many different levels, and they occur at the local level, they occur at the regional level, they also occur on the global level. So, for example, if you have a human rights practice that exists in a particular space, and which is different in certain respects from human rights practices in other places, that does not mean that they're not participating in the same global human rights project. They're just interpreting certain central commitments in a different way. So in a sense, anti-foundationalist theory is maybe not parochial, but it is definitely context sensitive in a sense of there being possibilities for different meanings ascribed to human rights in different contexts. So human rights may mean different thing for Inter-American Court of Human Rights, from European Court of Human Rights, or they may mean different things to Amnesty International, to what they mean to someone else. So that kind of context sensitivity is allowed within the broad confines of what human rights mean, which are actually shared for the most part, such as the idea of equal protection of human beings based on certain features, which is balanced against another. But the actual balance things between these different category grounds can be different in different contexts. So in a sense, yeah, I would call it context sensitive. I mean, not intending to avoid the question by changing the terms, but yeah, I hope it made sense what I said.
Can I follow on this one posed by Damir? If we want to a little bit push your argument or try to make some sort of maybe counter argument along these lines. First of all, if you speak about justification, that obviously implies that anti-foundationalism is also some sort of a normative endeavor. So there is element which necessarily by the very nature of justification as a process requires you to somehow ground your position in certain values. On the other hand, it's obvious that most of the job and most of the valuable stuff that anti-foundationalist doctrine can offer is maybe a better analytical reordering of the sometimes fuzzy world of human rights documents and practice. You may also say that it's better descriptive view. But when it comes to this point, it certainly is a problematic for foundationalist view to somehow reconcile the thesis about universality of human rights on the one hand, and the fact that you have all these levels that you mentioned. You have a global regime, you have regional regimes with various practices, you have local implementations even of these regional regimes. But if we reverse a little bit this problem for foundationalist doctrine and ask you for as an anti-foundationalist, how can you draw the lines about regional practices which may come under your anti-foundationalist doctrine as legitimate regional variations of human rights practice versus some sort of violation? When it comes to this point, I would say that foundationalists have more clear, so to say, grounds to argue, okay, this is against the human rights doctrine that we cherish. But you are in a way in a danger to justify all sorts of regional practices, or if you are not, then you have to draw some more clear lines, and in order to draw the lines you need to have some sort of ground to stand from which to argue that, and I'm curious what that ground might be in that sense. So
yeah, no, absolutely, very good question, thanks for that. When it comes to universality, so anti-foundationalism can explain universality in two ways. I mean, roughly one way would be that this kind of context sensitivity does not go all the way down, but that there is some core global practice which people accept, and then that kind of global practice necessitates some sort of universal concern for all human beings and so on. That's not the path that I want to take, although I do think that there is something to be said about that view. The second view is that, which I'm more inclined to argue for, is that universality is a normative. Yeah? So universality means that an actor would be willing to protect these kinds of features of human beings in the context of that kind of context of external reasons, if it were similarly placed always. Yeah? So it's a normative concern for all human beings that obtains from a particular evaluative standpoint, and that evaluative standpoint is determined by the practice. So in a sense, it's roughly analogous to debates about relativism. Yeah? So we have kind of agent relativism and appraiser relativism. Agent relativism is the incoherent version where you look at what the agent that you are evaluating thinks and then adopt that kind of view, which doesn't make sense. But the appraiser relativism is not incoherent, and this similar kind of thinking applies here. Because from the particular practice of human rights, which is part of the global practice, certain conclusions may differ, and so the ground is based on that evaluative perspective, which is embedded in the practice. And universality is understood as a normative commitment, and not as something that is to obtain in the practices of everyone for it to be upheld. So, for example, if you're faced with a clear situation of human rights violations somewhere in the world, and that there people do not accept basic ideas of human rights, that does not prevent you from acting on this view. Although it may make you more cautious, which I think is a virtue.
Okay, thank you very much.
We had a question from Anna Zdravković. So Anna, please unmute yourself. I don't know where your hand went, but I noticed it.
Thank you. Thank you, Bojan, but that's a bit late. Professor took my place. I wanted to follow up in regards to the universality. However, when you mentioned the context sensitivity about human rights, as long as I'm concerned, there is no denying that that is a basic characteristic. But I wanted to ask you if you could elaborate a bit more about context sensitivity and absoluteness of rights. Because I believe that they are context sensitive, but in a certain amount. Since if I am to claim that there is any kind of absoluteness or non-derogability, I need to ground it on some kind of minimum commonplace, right? So there needs to be some kind of content of those rights that is universal and that is not context sensitive. So yeah, thank you.
I agree completely. Context sensitivity just means that there are different levels on which human rights practices are. The most important level is global level, and the fact that what you refer to as minimum common content of human rights, in my view, is just explained by the fact that there is so much agreement on these kinds of protections in the world, and they're accepted because of that. And that actually the seriousness of these protections required this notion of absoluteness to be attached to it. However, I do think that a lot of this balancing against external justificatory ground, in my vocabulary, occurs at the level of determining the scope of the right, which has been developed historically in a particular way, and I think it still does happen. So in a sense, there is some core agreement. There is also scope for interpretation, if that makes sense. Which is then much more locally context sensitive than this core global agreement.
Okay, we are approaching the end of our session, isn't it, Bojane? Yes, it is. Okay. But if there is any other issue, then two things. First thing, I would like to thank Boško. We are very grateful for the time and effort you took to share with us your views. I assume that all participants share my view that we enjoyed and learned very much from you. If anyone wants to hear or wants to learn more from Boško, then I will again use this opportunity and refer you to the latest issue of Pravni Zapisi. There you can read the excellent guest editorial written by Boško, Constructing the Constitutional Self, Meaning, Value, and Abuse of Constitutional Identity. So another topic very, very explained by Boško. I have to prove what Miško claimed about myself. Sorry. And I think, Bojan, you should have the last word.
Definitely. I'll even, in order to support the effort, I'll even share the link in the comments section for everyone.
Thank you very much.
So here you go. Thank you, thank you so much, Boško. It was an honor to meet you, and I'm very glad that we invited you, and I'm very glad that you came. So today you become the official friend of Belgrade Legal Theory Group, and we'll definitely call you as soon as there is a chance for these kinds of events and bigger events. It's important on so many levels. Some of our members, as I mentioned at the beginning, maybe in Serbia, I don't even recall. One of their main topics is human rights. So if it was interesting for me, and I don't do human rights, and it was very interesting, it was most definitely interesting to them. Hopefully you'll join us when we have other meetings. We'll include you, Teodora will include you in our mailing list, so you'll get the invitations on a regular basis, I hope. Thank you everyone for participating and for a wonderful discussion. Violetta was as usual, a very good moderator, and I thank her for moderating this session and insistent, since as academic conversations tend to have a slow start. This one also had a slow start, but it definitely developed by the second half of it. So thank you everyone once again for participating. I invite you to follow our updates on Facebook and via email. Who get it via email, you can always shoot a mail to Teodora Miljojković and ask her to include you in our mailing list if you're into those kinds of things, like mailing lists, and people for some reason are. So thank you once again everyone, and hope to see you really soon. Boško?
Can I just add, sorry, Bojan, can I just add to really grateful for having me in this forum. I hope we will meet soon in normal way, not virtual way, but just to thank you for all your questions, for all the engagement, and if you want to talk about these issues more, for anyone doing work on human rights, please do get in touch. I would be glad to discuss it further.
Thank you so much. Bye.
Ciao. Ciao.
Bye.